I have presided over more than 2 decades of criminal trials, frauds, murders, political scandals, and cases that shook entire families to their core. But this one still echoes inside my courtroom even after all these years. It began on a morning that looked completely ordinary in the federal courthouse. The kind of morning where you expect routine motions, predictable arguments, and controlled legal exchanges. Then the defendant walked in, Daniel Carter, the son of a powerful U.S. senator. Man raised in the spotlight, yet trying desperately to look like he didn't belong to it. I remember how carefully he adjusted his suit, how controlled his breathing was, but his eyes betrayed something far heavier. Fear, not of punishment, fear of being misunderstood. And believe me, in my years on the bench, I've learned something very specific about fear. Innocent people don't fear the truth itself. They fear how quickly it can be twisted. Behind him sat his legal team, and across the aisle, the prosecution. But what caught my attention wasn't the attorneys, it was her. Emily Dawson, a young woman composed, almost unsettlingly calm. She wasn't crying, she wasn't shaking, she wasn't doing what most alleged victims do when they walk into a courtroom carrying trauma. Instead, she was watching Daniel, not with anger, but with precision, like she was studying a result she had already calculated. That detail, I noticed it immediately. The prosecutor stood and delivered the opening statement, describing what they called a calculated honey trap scheme, alleging Daniel Carter had used his political influence and charm to manipulate Emily Dawson into a private encounter that was secretly recorded and later weaponized. The words were heavy. But courtrooms are built on words, not truth, at least not immediately. As I sat there, I remember scanning the jury. 12 ordinary citizens pulled into an extraordinary storm. Some already looked convinced. Others were confused. And a few were carefully neutral, the way experienced jurors often are when they sense something doesn't fully align. Then the prosecution played the first piece of evidence, a video clip. Even before it fully loaded, I saw Daniel Carter's posture tighten. That reaction told me more than any testimony could. The video showed what appeared to be a private hotel room meeting between Daniel Carter and Emily Dawson. The framing was deliberate, too clean, too centered, almost staged. But what truly disturbed me wasn't what was shown, it was what was missing. In my experience, real moments of emotional or criminal escalation are rarely so perfectly framed. Life is chaotic. Evidence rarely arrives in such polished form unless someone has taken great care to design it that way. I leaned forward slightly, watching the jury more than the screen. That's when I noticed something else. Emily Dawson never looked at the video. Not once. She kept her eyes on Daniel Carter, and she smiled. Not a broad smile, a small, controlled expression, the kind that disappears before most people even register it. I remember thinking to myself in that moment, this is not a victim watching her trauma unfold. This is someone watching a performance reach its first act. Daniel's defense attorney immediately objected, arguing the video was taken out of context and potentially manipulated. But objections are easy to make in court. What matters is what the jury absorbs before the judge even rules, and I could already see it happening. The narrative was forming: politician's son, private hotel room, act recording, honey trap accusation. It was almost too perfect. And perfect cases are often the most dangerous ones because perfection leaves no room for doubt. And without doubt, there is no justice. Only conclusion. But then something happened that changed the temperature of the entire courtroom. The defense requested to cross-examine Emily Dawson immediately. She agreed. Too quickly. I still remember the silence when she stepped toward the witness stand. Every sound in the room seemed to disappear, as if the courthouse itself understood that something significant was about to unfold. Daniel Carter didn't look at her, not even once, but I saw his hands tremble slightly as she took the oath. And that was the first moment I felt it, not certainty, not judgment, but imbalance. Something in this case was not aligned the way it should have been, and I was about to learn just how deep that imbalance went. Because when Emily Dawson finally opened her mouth to testify, the first sentence she spoke didn't sound like accusation. It sounded like preparation. And that's when I realized this wasn't just a honey trap case. It was something far more controlled, far more deliberate, and far more dangerous than anyone in that courtroom was ready to admit. I remember gripping my pen slightly tighter, watching her closely as she turned toward the defense table and said the words that would shift the entire direction of this trial. Words that made even the prosecutor glance at her in confusion because they weren't in the script they expected, not even close. When Emily Dawson leaned into the witness stand, the entire courtroom seemed to tighten like a stretched wire. I've seen hundreds of witnesses take that oath, but very few take it like she did. No hesitation, no emotional tremor, no glance toward the jury for sympathy, just a steady voice and eyes locked on Daniel Carter as if the rest of the courtroom didn't exist. And then she began. She described meeting Daniel Carter at a charity event in Washington, D.C. A gathering filled with donors, lobbyists, and political families who smiled for cameras while trading influence behind closed doors. Her words painted a familiar picture. But something about her delivery felt rehearsed in a way that made my instincts uneasy, not necessarily dishonest, but structured, carefully structured. In my experience, truthful witnesses remember, but strategic witnesses construct. The prosecutor guided her gently at first, asking her to explain how their communication began. Emily said it started with polite messages, then private conversations, then emotional closeness, and finally, the meeting at the hotel. Each step sounded logical, sequential, clean. Too clean. I remember glancing at the jury again. They were following her story like a straight road. No contradictions yet. No visible cracks. That's usually how strong narratives work in court until cross-examination begins to dig beneath the surface. Then the defense attorney stood Michael Reeves, a sharp, experienced lawyer who had defended political families before. He didn't rush. He didn't raise his voice. He simply walked toward her with the calm of someone who already believed the story wasn't as simple as it looked. That calm matters more than aggression in a courtroom. Aggression is emotional. Calm is strategic. He began with the simplest possible question. Ms. Dawson, you claim Mr. Carter initiated all communication? Yes, she replied without blinking. And you responded because you were afraid of political pressure? Yes. A pause even, I noticed it. That kind of consistency without emotional fluctuation can either mean truth or preparation. Then Michael Reeves did something subtle. He didn't attack her story. He attacked its timeline. Can you tell the court the exact date you first received a message from Mr. Carter? She hesitated, not long, but long enough, just a fraction of a second. Then she answered. The defense attorney immediately requested the phone records to be entered into evidence. And that's when I noticed the first ripple in the prosecution's confidence, because courtroom truth is rarely destroyed by dramatic revelations. It is dismantled by small inconsistencies. The phone records were projected onto the screen. I remember the exact moment the jury leaned forward slightly. There it was, a gap, a missing block of communication, not between Daniel Carter and Emily Dawson, but between Emily Dawson and an unknown number that had been heavily encrypted. The prosecutor quickly objected, claiming relevance issues, but I allowed it because something about that gap didn't feel accidental. And Emily's expression changed for the first time, not fear, not panic, something more controlled, adjustment, as if she had anticipated the question, but not the timing. Michael Reeves continued. Is it true, Ms. Dawson, that during the period you claim Mr. Carter was coercing you, you were also in contact with a private media consultant? The courtroom shifted instantly. Even the air felt heavier. Emily paused again, this time longer, and when she answered, her voice was still steady, but slightly colder. Yes, a murmur spread through the gallery. I had to strike my gavel once to restore order. Now things were no longer linear. Now the story had started bending. The defense requested the consultant's records. The prosecution objected again. But I was already watching Emily Dawson closely, because I've learned something important over the years. In real honey trap cases, the trap is never just emotional. It is logistical, and logistics always leave traces. Michael Reeves walked back toward his table, then turned once more. One final question. Ems. Dawson, did you ever personally initiate contact with Mr. Carter after your first meeting? Silence, a long silence, the kind that makes jurors uncomfortable enough to shift in their seats. Emily finally spoke. No, but I saw it. A micro-expression. Just for a fraction of a second, a tightening at the corner of her mouth. And in that moment, A.B. made a mental note I will never forget. This witness was not simply recalling events. She was managing them. And when someone manages the truth too carefully in a courtroom, it usually means there is another layer waiting beneath the surface, a layer no one has touched yet. And I had a growing suspicion that Daniel Carter was not the only person on trial here. Because somewhere between those messages, that hotel room, and that encrypted number, something much larger was operating in the background, something that hadn't shown its full face yet, and the next piece of evidence was about to bring it dangerously close to the surface. The moment the defense requested the next set of evidence, I could feel the entire courtroom shift again, this time not toward certainty, but toward discomfort. There is a particular silence that forms in trials like this. It is not the silence of calm. It is the silence of anticipation. When people begin to sense that whatever they believe right now might not survive the next 5 minutes. Michael Reeves stood at the podium again, his tone unchanged, steady, controlled, almost surgical. Your Honor, the defense requests admission of metadata analysis and device-level communication logs tied to the complainant's submissions. The prosecution objected immediately, too quickly, and I remember thinking that speed matters. In court, hesitation can reveal uncertainty. But overreaction often reveals fear of exposure. I allowed the evidence, and that decision changed the atmosphere in the room instantly. The screen behind me flickered to life. Digital records, Mausch timestamps, Dedvisi identifiers. Network logs, at first glance, it looked technical, almost boring to the jury. But I've learned something over years on the bench. Jurors don't understand data immediately, but they understand patterns once they are shown clearly enough, and Michael Reeves knew exactly how to present it. He pointed toward the timeline. Ladies and gentlemen of the jury, you are looking at the communication timeline presented by the prosecution. A straight line appeared on the screen, clean, organized, predictable, almost identical to Emily Dawson's testimony. Then he paused. And now you will see the forensic reconstruction from the defense expert. A second timeline appeared beneath it. And that's when the first real crack formed, because the two timelines did not match, not slightly, not interpretively, but structurally. There were entire communication blocks that appeared in one and were completely absent in the other. A juror in the front row leaned closer. Another whispered something under their breath before stopping themselves. I remember tightening my grip on the pen again, not because I was surprised yet, but because I knew what this meant. This was no longer a credibility dispute. This was a data integrity conflict. And in modern cases like this, data does not lie. People interpret it. People manipulate it. But raw forensic extraction always leaves footprints. Michael Reeves continued. Your Honor, the defense expert has identified a pattern of selective extraction from a single device source. Certain communications were exported while others were excluded from the prosecution's submission. The prosecutor immediately stood. That is speculation. The defense is attempting to confuse the jury with technical jargon, but I stopped him because I had already seen enough to justify hearing it fully. And Emily Dawson, she remained still. But I noticed something now that I hadn't seen before. Her calmness was no longer natural, it was maintained. There is a difference between emotional control and emotional suppression. Control is effortless, suppression requires effort, and effort eventually leaks. Michael Reeves pressed further. Ms. Dawson, did you personally hand over your device for forensic extraction? Yes, she replied. Was the device in your possession the entire time before submission? Yes. Was anyone else given access to it during that period? A pause. Longer this time. The courtroom felt it. Even the jury felt it. Emily finally answered, no. But I leaned slightly forward in my chair because I noticed something very specific. She didn't say it like certainty. She said it like protection. And protection usually implies vulnerability somewhere else. The defense then revealed something I will never forget. A third-party cloud sync connection, active during the timeline of the alleged honey trap incident, not initiated by Daniel Carter, not controlled by Emily Dawson alone, but tied to an external administrative account. And when the screen displayed the account identifier, the prosecution's entire posture changed. For the first time in the trial, I saw genuine disruption, not strategy, not objection, disruption. The account was linked to a private consultancy firm specializing in political reputation management, the kind of firm that doesn't appear in public narratives, but often appears in the background of high-stakes political damage control. A murmur spread through the courtroom, again louder this time. I struck the gavel once more, but I could not silence what had already formed in the minds of everyone present, because now the question was no longer whether Daniel Carter was guilty. The question was becoming something far more dangerous. Who constructed this entire narrative, and why? Emily Dawson finally broke eye contact with Daniel Carter for the first time. And when she did, AB saw something in her expression I had not seen before. Not confidence, not control, something closer to calculation under pressure, as if she realized the courtroom was no longer following her script. And when that realization arrives in a witness, it usually means the next revelation will not come from testimony. It will come from exposure. Michael Reeves adjusted his papers slowly, then looked toward me. Your Honor, the defense is prepared to present the origin point of the recorded hotel footage. That sentence landed heavier than anything spoken before it. Because origin points, in my experience, are where truth and fabrication finally separate, and I could already feel it coming. Something inside this case was about to surface fully. And once it did, there would be no way to return to the version of events the prosecution had built. When Michael Reeves said those words, the origin point of the recorded hotel footage, I noticed something shift that I have only seen a handful of times in my entire career. It wasn't loud, it wasn't dramatic, it was psychological. The entire courtroom collectively understood that we were no longer dealing with testimony or interpretation or even conflicting narratives. We were about to deal with creation. And creation is the most dangerous thing to expose in a courtroom because it doesn't just question a story, it questions intent. The prosecution immediately objected again, this time more forcefully. Your Honor, this is a fishing expedition into irrelevant media provenance. But I didn't respond right away because I was watching Emily Dawson, and I saw it. For the first time in the entire trial, her composure wasn't just strained, it was reactive. A slight shift in posture, a tightening around the jaw, not fear yet, but recognition. As if she understood exactly what document or file was about to be introduced. That matters more than anything else. In my experience, surprise is not random in court, it is diagnostic. I allowed the defense to proceed. The courtroom lights dimmed slightly as the projector activated again, and then it appeared the hotel footage again. But this time, not the video itself, the source chain metadata behind it. Michael Reeves walked slowly, deliberately. Ladies and gentlemen of the jury, what you saw earlier was presented as spontaneous evidence, but every digital file has a birth certificate. He pointed to the screen. This is the file origin analysis. Rows of technical logs filled the display, but he didn't let the jury drown in it. He simplified it immediately. Let me make this clear. This footage was not recorded on a personal phone. It was not uploaded directly from a witness device, and it was not extracted from any recovered handset belonging to either party. A pause. The jury was locked in now. Even I could feel their attention narrowing. He continued. This file was compiled, rendered, and exported through a third-party editing pipeline. The word edited hit the room differently than I expected, because edited does not just imply manipulation, it implies construction. The prosecutor shot up again. Objection! That conclusion is speculative and inflammatory, but I interrupted. Overruled. The witness will continue. And then came the turning point. Michael Reeves clicked again. A visual diagram appeared, little routing cloud nodes, external access points, and at the center of it all, a time-stamped connection log tied to an IP cluster registered under a political consulting firm based in Washington, D.C. The courtroom did not react immediately. It took a second. Sometimes juries need time for meaning to form. Then I heard the first whisper, then another, then silence again. But it wasn't the same silence as before. This one was heavier, because now the implication was unavoidable. This was not just a relationship dispute, not just a honey trap allegation. This was constructed evidence presented as lived reality. Emily Dawson finally spoke again, her voice quieter than before. That doesn't prove anything about me. And I remember that sentence very clearly because it was the first time she sounded human, not controlled, not rehearsed. Human Michael Reeves turned toward her immediately. That's exactly what we are here to determine, Ms. Dawson. Then he leaned slightly forward. Who gave the instruction to assemble this footage? A long silence followed. I watched her closely, too closely, perhaps, because in court, silence is never empty. It always carries negotiation inside it. And then she said something that changed everything again. I didn't assemble anything, but her voice cracked just slightly, not enough for the jury to fully notice, but enough for me to see it. And that crack was not emotional. It was structural, the kind of crack that appears when someone is holding back information they were never meant to reveal in public. Michael Reeves didn't push immediately. He let it sit. That is a skilled technique. Let silence pressure the witness, not questions. Then he spoke again. Then who did? Another silence, longer this time. And I remember looking at Daniel Carter at that exact moment. He still hadn't spoken. He still hadn't reacted. But his eyes were no longer focused on Emily Dawson. They were focused somewhere behind her, as if he had just realized something deeper than the courtroom narrative, something he had not understood before. And that's when it happened. The judge, myself, received a sealed motion from the defense. I opened it immediately. And as I read the first line, Abby felt something I rarely feel on the bench, not doubt, not surprise, but concern about what comes after the truth is revealed, because the document alleged something far more serious than framing. It alleged coordination between multiple actors across multiple communication channels to manufacture a political scandal from a controlled encounter. And at the center of that allegation was not just Emily Dawson, not just Daniel Carter, but someone whose name had not yet been spoken in open court. I lowered the paper slowly, and I remember thinking one thing very clearly. This trial was no longer about innocence or guilt. It was about who orchestrated reality itself. The next revelation was about to name the invisible hand behind everything we had seen so far. I remember the exact moment I decided this case had crossed a threshold, not legally, morally. There is a difference in a courtroom. Legal thresholds are procedural. You rule, you admit, you exclude. But moral thresholds, those are internal. You feel them when a case stops being about two parties and starts revealing a system underneath them. The sealed motion sat in my hands for several seconds longer than it should have. In my experience, when experienced defense counsel chooses to present something directly to the bench in a sealed format at this stage of trial, it is never routine, it is never minor, it is always controlled escalation. I opened it. The first page was enough to change the temperature in the room for me, even if no one else knew it yet. It referenced coordinated digital activity patterns, cross-account synchronization, and an administrative oversight layer tied to reputation management infrastructure. But what struck me wasn't the technical language, it was the implication forming between the lines. This was not just about a manipulated video, this was about faffy-structured narrative architecture. I looked up from the document. Emily Dawson was still standing in the witness box, but something had changed in her stillness. It was no longer the stillness of control, it was the stillness of anticipation, like someone waiting for a door to open that they already knew existed. Daniel Carter, on the other hand, hadn't moved at all, but his expression had shifted subtly, not relief, not confusion, recognition. That disturbed me more than anything else, because recognition usually means a person is not learning the truth. They are confirming it. I placed the motion back down and addressed the courtroom. The court has received a sealed defense submission containing allegations relevant to evidentiary origin and coordination. I paused, and I chose my next words carefully. At this stage, the court will permit limited inquiry into the source attribution of the contested media file. The prosecutor immediately stood again. Your Honor, this is unprecedented. I cut him off. Unprecedented does not mean inadmissible. And that line, I still remember it clearly, because it wasn't just a ruling, it was a warning. Michael Reeves didn't waste a second. He turned back to the jury. Ladies and gentlemen, everything you have seen so far has been presented as a single event. A private encounter between two individuals that escalated into criminal allegations. He took a step forward. But what if that event was not spontaneous at all? The courtroom tightened again, not silence this time, focus. He clicked the remote. A new visual appeared. Network diagrams, multiple devices, multiple access points, and at the center an orchestration hub, a centralized coordination node used to manage timing of uploads, metadata alignment, and distribution sequencing. A juror visibly frowned. Another leaned back as if physically distancing themselves from what they were seeing, and then Michael Reeves said the line that changed everything. This is not a recording of an incident. He pointed at the screen. This is a constructed sequence designed to simulate an incident. The prosecutor shouted objection again, but I didn't respond immediately because I was watching Emily Dawson, and for the first time, she looked down not at Daniel Carter, not at the jury, at the floor. And I've learned something over the years. People look down when they are no longer managing the narrative. They look down when they are calculating what comes next. Michael Reeves continued, softer now. The defense does not claim that emotions, conversations, or interactions were fabricated entirely. What we are demonstrating is that those interactions were guided, recorded, and assembled into a prosecutorial narrative before any complaint was formally filed. A pause, and then he added, that raises a question this court cannot ignore. He turned toward Emily Dawson. Were you a victim of Mr. Carter, a beat, or were you positioned as a participant in a pre-structured operation? That word positioned landed like a hammer. Emily finally looked up again, and when she did, Abby saw something that made even me sit more upright. Not anger, not denial, conflict, because in that moment she didn't respond like someone defending innocence. She responded like someone deciding how much truth she could safely allow to exist in public, and then she said it very quietly. I didn't know everything that was happening. The courtroom reacted instantly. Whispers broke out. The prosecutor turned sharply toward her. Daniel Carter finally moved, just slightly, his head lifting as if that sentence had confirmed something he had been afraid to believe. And I felt it too, because that was not a denial. It was a fracture line opening inside her testimony. Michael Reeves didn't push immediately. He let it breathe, then he asked the final question of the moment, then who did? And for the first time in the entire trial, Emily Dawson did not answer quickly. She hesitated long enough for the entire jury to notice. Long enough for the prosecutor to realize control was slipping, long enough for me to understand that whatever name came next would not just define guilt, it would define intent. And intent in a courtroom like this is where entire cases collapse or transform into something far larger than anyone expected. I remember tightening my grip on the bench just slightly because I knew what was coming next. And I also knew once it was spoken aloud, there would be no way to return this trial to what it once was. Emily Dawson's silence that day was not the silence of confusion. I want to make that clear as someone who has watched thousands of witnesses struggle under pressure. Confused witnesses rush to fill silence. Honest witnesses try to clarify, but calculated witnesses, they measure silence first. And that is exactly what she did. The entire courtroom waited for her answer to Michael Reeves' question. Then who did? Even the prosecutor seemed to realize something was slipping out of his control. He leaned forward slightly, as if proximity could somehow stabilize the narrative. Daniel Carter didn't speak, but I watched him closely. His expression was no longer defensive. It was expectant. That detail mattered more than anything the attorneys were arguing, because in courtroom psychology, expectation often reveals prior knowledge. Emily finally lifted her gaze, and when she spoke, her voice was quieter than before, but not weak, controlled, carefully controlled. I didn't know their names. A murmur spread instantly through the courtroom. The prosecutor stood again. Your Honor, this is speculative. She is. I raised my hand. Let her finish, because I had learned something important in cases like this. Interrupting uncertainty often hides truth inside it. Michael Reeves didn't react. He simply observed her. Emily continued. There were people communicating with me through intermediaries. I never spoke directly to anyone outside the arrangement. That word, arrangement, landed heavily. Juries don't always understand legal language, but they understand meaning. An arrangement does not belong in a simple victim narrative. I leaned slightly forward because now we were no longer discussing a single alleged incident. We were discussing structure. Michael Reeves took a step closer. Was Daniel Carter part of that arrangement? A pause, shorter this time, but sharper. Yes. The courtroom reacted instantly, not loudly, but collectively. A synchronized shift of attention toward Daniel Carter. But what I noticed, again, was not his reaction to being accused. It was his reaction to how she said it. There was no emotional emphasis, no anger, no fear. It sounded procedural, like she was identifying a role rather than describing a crime. And that is when the case changed direction in my mind. The prosecutor finally stood, voice sharper now. Your Honor, the witness is clearly under pressure and attempting to rewrite her earlier testimony. But I stopped him. Counsel, sit down. He hesitated, then sat. And in that moment, I realized something critical. Control in a courtroom is not maintained by volume. It is maintained by timing, and the defense had seized timing. Michael Reeves turned toward the jury again. Ladies and gentlemen, let's step back from interpretation for a moment. He clicked the remote. A new visual appeared, not messages, not video, but communication flow architecture, nodes, agents, relay points, and a structured pathway showing how information moved between identities. The jury leaned in again. Even I felt the weight of it, because this wasn't evidence of a simple interaction anymore. It was evidence of coordination. Michael Reeves pointed at the diagram. This is the reconstructed communication network used during the period in question. Then he pointed to a highlighted segment. And this node here represents an intermediary account that was not disclosed in the prosecution's initial filing. The prosecutor immediately objected again, but I allowed continuation because at this stage, suppression would have done more damage to the court's integrity than admission. Michael Reeves continued. This intermediary account did not belong to Daniel Carter. A pause. It did not belong to Emily Dawson. Another pause. It belonged to a contracted external operator working on political risk mitigation cases. That phrase changed the room because now it was no longer about individuals. It was about systems that operate around individuals. Emily Dawson looked down again. But this time, it was different. Not submission, not calculation, something closer to exhaustion. As if maintaining the structure of her testimony was becoming increasingly difficult, Michael Reeves softened his tone. Ms. Dawson, were you ever told how your communications would be used? A long silence followed, and I remember thinking, this is the moment where witnesses either break a case open or close it forever. She finally answered, no. But I noticed something subtle again. Her voice no longer carried certainty, it carried distance, as if she was stepping away from her own statements as she spoke them. And Daniel Carter, for the first time, he exhaled, not dramatically, just enough for me to notice, as if something he had been holding inside for a long time had just been partially confirmed. Michael Reeves returned to his table briefly. Then he said something that I still remember clearly. Your Honor, at this point, the defense requests permission to introduce a classified communication audit linking the intermediary network to pretrial narrative-shaping activities. The prosecutor looked at me immediately, so did the jury, and I understood the weight of the moment. Because whatever I allowed next would determine whether this remained a standard criminal trial or became an exposure of something far more complex than anyone in this courtroom had prepared for. I looked at Emily Dawson one more time, and she was no longer watching anyone. She was staring straight ahead, as if waiting for the final piece of a structure she had already lived through, but had never been allowed to fully see until now. And I made my decision. "Proceed." The defense attorney nodded once, and as he turned back to the screen, I knew the next revelation would not just challenge testimony, it would challenge the entire origin of the case itself. And once that origin was exposed, there would be no way to restore the version of events everyone had believed at the beginning. When I said "proceed," I remember the exact moment the courtroom changed, not in noise, not in movement, but in expectation. It's a strange thing that happens in trials like this. People stop listening like they are in a courtroom and start watching like they are in a documentary where the ending is already being rewritten in real time. Michael Reeves didn't rush. He understood something most attorneys forget under pressure. If you move too fast at the point of revelation, the jury remembers confusion instead of truth. So he slowed everything down. He turned to the screen, but before introducing anything, he addressed the courtroom directly. "Your Honor, what you are about to see is not speculation. It is not interpretation. It is a forensic reconstruction of communication routing behavior extracted from authorized audit logs." Then he paused and looked at the jury, and it shows something very simple, a beat that this case did not begin with a complaint. The courtroom tightened instantly. I felt even the prosecutor shift in his seat. Michael continued, "It began with coordination. The word hung in the air longer than expected, then the display lit up, but this time it wasn't messages, it wasn't video, it was timeline synchronization data. 3 columns appeared: message preparation timestamps, external review timestamps, and then a 4th layer appeared underneath: pre-incident narrative draft logs. I remember the silence lens that followed, not because the jury understood everything technically, but because they understood the implication immediately. This was planning, not reaction. The prosecutor stood sharply. "Your Honor, this is absolutely misleading. These logs do not prove intent." I looked at him calmly. "Counsel, sit down." He hesitated, then sat again, more slowly this time, because even he understood something was slipping past argument now. Michael Reeves pointed at the first column. Notice the first entry: media capture event timestamp. Then he moved to the second. Notice the editing pipeline activation begins before the alleged victim's formal statement was recorded. A pause. That detail mattered. Even jurors who didn't understand digital forensics understood sequencing, cause and effect, action and reaction. But here, reaction was happening before action, Michael continued, and this is where it becomes critical. He highlighted a cluster of entries. These are internal review notes from a contracted communications intermediary. The screen zoomed in, redacted identifiers, but visible structural markers. And one phrase repeated across multiple logs: emotional framing consistency check. A juror frowned. Another shook their head slightly, like they were trying to make it make sense. And I could feel it too. Because once you introduce emotional calibration into evidence handling, you are no longer dealing with truth collection. You are dealing with narrative engineering. Emily Dawson finally spoke again. But this time, her voice was different. Not stronger, not weaker. Detached. What is that supposed to mean? It wasn't directed at the defense. It was directed at the structure itself. Michael Reeves turned toward her. "It means, Ms. Dawson, that your statements were not only recorded, they were evaluated for emotional alignment before they were submitted to court," a pause, "and adjusted if they did not match the required narrative structure." The courtroom reacted immediately. Whispers, movement. A juror actually looked toward the prosecution table. That is never a good sign. The prosecutor stood again. "This is absurd. This court is being manipulated by technical misrepresentation." But I raised my hand. "Counsel." He stopped. I leaned slightly forward. "Argue facts, not frustration." That sentence landed heavier than intended, because frustration in a courtroom often signals loss of control. Michael Reeves continued. "And now we arrive at the most important layer." The screen changed again, this time showing a single central node, an administrative account labeled only as Case Narrative Coordinator. A collective silence followed. Even I felt it, because labels like that do not belong in criminal proceedings between 2 individuals. They belong in systems, structured systems. And then Michael Reeves said the line that shifted everything again. This account controlled the sequencing of evidence release, not the witnesses. The room went still, and it was active before Ms. Dawson ever entered this courtroom as a complainant. I remember looking at Emily Dawson at that exact moment, and for the first time, she didn't respond, not even with her eyes. It was as if something in her had reached a limit where reaction was no longer possible. Daniel Carter finally spoke, quickly, almost to himself. "So it wasn't me." He didn't finish the sentence, but he didn't need to, because everyone understood what he meant. Michael Reeves didn't capitalize on the moment immediately. He let it breathe. Then he said something far more precise. "No, Mr. Carter." A pause. You were part of a sequence. And then he turned toward the jury, and the question now is not who committed a single act. It is who designed the sequence in which all of you were meant to believe it happened. I remember gripping the bench slightly again, because at that point I understood something irreversible. We were no longer evaluating guilt. We were evaluating construction of reality inside a legal system, and the final piece of that construction had not yet been revealed. But it was already moving toward the surface, and when it surfaced fully, this courtroom would not remain the same. The moment Michael Reeves said, "You were part of a sequence," I remember looking across the courtroom and realizing something unsettling. No one was breathing normally anymore, not the jury, not the attorneys, not even the spectators sitting at the back who had come expecting a routine political scandal trial. This had become something else entirely. A courtroom that no longer felt like it was deciding guilt, but unraveling a system that had already made decisions long before we ever convened. I leaned back slightly, forcing myself to maintain judicial control, because in moments like this, a judge cannot be absorbed into the narrative, even when the narrative is actively reshaping itself in real time. Michael Reeves didn't speak for several seconds. He let the silence do its work. Then he finally said it. "Your Honor, the defense now moves to introduce the final layer of evidence in the narrative coordination chain." That sentence landed differently. Final layer, not another piece, not another argument. Final, the prosecutor immediately stood again, but this time his voice had changed. Less aggressive, more urgent. "Your Honor, this is beyond the scope of the original charges. This is a restructuring of the entire case." And for the first time, I saw hesitation in his strategy, because he understood what was happening. He was no longer defending a case. He was defending the framework in which the case existed. I looked at him, then at the jury, then at Emily Dawson, and I made a decision. This court will hear the final submission. The prosecutor sat down slowly, not defeated, but aware. Michael Reeves walked back toward the screen, but instead of immediately displaying evidence, he turned to Emily Dawson. And when he spoke, his tone changed, softer, not aggressive, almost careful. Ems Dawson, before I show this, I want to ask you one final question. The entire courtroom focused again, even I felt the shift. Do you know what an orchestrated testimony environment is? Emily didn't answer immediately, and for the first time I saw something break through her controlled exterior. Not emotion, recognition mixed with discomfort. "I don't know what you're trying to imply." Michael nodded slightly. "I'm not implying anything. I'm asking whether anyone ever explained to you how your statements would be structured before you ever entered this courtroom." He silenced longer this time, and then she finally said it. "Yes." The word barely carried, but it changed everything. A juror visibly reacted. The prosecutor leaned forward sharply. And I remember thinking that was the first time she admitted the existence of external structuring without understanding its full meaning at the time it was applied. Michael Reeves turned back to the screen. "This is the final audit layer." The display changed again. But this time, it wasn't complex diagrams. It was simple text logs, decision notes, instruction chains, and approval signatures. But one line stood out above everything else: ensure narrative consistency across complainant testimony, media framing, and preliminary legal filings prior to court initiation. The courtroom didn't react immediately. It took a second, then another. Then I heard a juror whisper, "Before court initiation." That was the turning point. Because that phrase doesn't belong in a system responding to a crime. It belongs in a system preparing a case before the legal system is even engaged. The prosecutor stood again, but his voice was quieter now. "This could refer to administrative preparation. This does not prove manipulation of testimony." Michael Reeves nodded once. "Correct." A pause. Then he said the sentence that changed the direction of everything. "It does not prove manipulation of testimony." Another pause. "It proves manipulation of context before testimony existed." The courtroom went completely still, even I felt it, because context is everything in law. If context is engineered, then interpretation becomes meaningless. And before I could even process the full implication, Michael Reeves clicked the final file. A name appeared on the screen, not redacted, not hidden, fully visible, the supposed coordinator of the entire communication and narrative structure. And the moment that name appeared, Abby saw something I had never seen before in a courtroom of this level. The prosecutor didn't object, he didn't speak, he didn't even move, he just stared. And Emily Dawson, for the first time since the trial began, closed her eyes. Not in denial, not in defiance, but in recognition of something she had been trying not to fully confront. And Daniel Carter slowly leaned back in his chair, as if the weight he had been carrying for weeks had finally shifted, but not fully lifted. I remember gripping the bench again because I understood something very clearly in that moment. Whatever this name represented, it was not just a person. It was the origin point of the entire courtroom reality we had been navigating. And once that origin is exposed, everything built on top of it becomes unstable. The jury knew it, the attorneys knew it, and I knew it too. And then I looked at the defense attorney one more time. As he prepared to speak the name out loud in a federal courtroom for the very first time, the courtroom didn't feel like a courtroom anymore. It felt like a sealed room where reality itself had been slowly dismantled piece by piece, and we had finally reached the core holding everything together. Michael Reeves stood still for several seconds after the name appeared on the screen. Even he understood the weight of what was about to happen, because once a name is spoken in a federal courtroom with this level of implication, it does not just enter the record. It enters history. I remember adjusting slightly in my seat, not because I was uncertain, but because I knew the responsibility of this final moment rested entirely on my ruling. The prosecutor didn't move. He didn't object. He didn't even attempt damage control anymore. That alone told me more than any argument could. Emily Dawson was still seated in the witness box, but she no longer looked like a witness. She looked like someone standing at the edge of a story she had been inside long before she understood its shape. And Daniel Carter, for the first time since this trial began, he looked away from her completely, not in anger, not in betrayal, but in acceptance. Michael Reeves finally spoke. His voice was calm now, not dramatic, not forceful, final. Your Honor, the name listed in the final orchestration layer is Jonathan Pierce. A silence followed so complete that even the air felt suspended. Jonathan Pierce, a political operations strategist known in Washington circles, not a public figure in the traditional sense, but someone who operated behind campaigns, media coordination, and crisis containment structures, the kind of individual whose influence is not measured by visibility, but by outcomes that seem to appear naturally in public narratives. I remember the exact moment the courtroom processed it, not immediately. It took seconds. Then realization spread slowly, like ink in water. A juror blinked repeatedly. Another leaned back. The prosecutor finally exhaled, but it wasn't relief. It was acknowledgement that the structure of the case had fundamentally shifted beyond his control. Michael Reeves continued. This individual is linked through verified audit trails to the intermediary network responsible for coordinating communication timing, media framing alignment, and pre-complaint narrative structuring. He paused. And we are prepared to demonstrate that both parties in this courtroom were engaged without full awareness in a controlled interaction sequence designed to produce a predetermined legal conflict. Emily Dawson finally spoke again, but her voice was different now, not controlled, not structured, quiet. I didn't know I was part of anything like that. And for the first time, A.B. believed her tone more than her testimony, because in courtroom experience, there is a difference between deception and being used as a variable in someone else's design. Daniel Carter turned slightly toward her, not fully, just enough, and said something I will never forget. So neither of us were in control. It wasn't a question. It was realization. Michael Reeves didn't respond immediately. He let the courtroom sit inside that truth. Then he addressed me. Your Honor, at this stage, the defense moves to dismiss all charges due to evidentiary contamination and narrative fabrication prior to judicial engagement. The prosecutor finally stood, but his voice was no longer forceful. It was restrained. This court cannot retroactively assume intent based on external coordination theories without direct causation of the alleged act. And for the first time, he was right to a degree, because even in a corrupted or engineered narrative, a court must still distinguish between influence and action. I looked at both sides, then at the jury, and finally at Emily Dawson and Daniel Carter, and I understood the real difficulty of this case. The truth had not been absent. It had been distributed across multiple controlled layers until it became indistinguishable from design. I finally spoke. The court acknowledges the extraordinary nature of the evidence presented. A pause. This does not in itself determine criminal liability for the charged act. The courtroom tightened again because they realized something important. We were not ending with total absolution. We were ending with legal precision applied to an emotionally unstable truth structure. I continued. However, another pause. The court finds sufficient basis to question the integrity of the evidentiary origin, the chain of custody, and the contextual framing of the prosecution's central submission. I looked at the prosecutor, and therefore all charges against Daniel Carter are dismissed without prejudice. A sound moved through the courtroom, not celebration, not outrage, disorientation. Daniel Carter didn't react immediately. Emily Dawson closed her eyes again, but this time longer. Not in relief, in processing. Michael Reeves lowered his head slightly, not victory, resolution. I leaned forward one final time, because as a judge, the final words are never procedural. They are reflective. I've spent my career believing that courtrooms uncover truth. A pause. But cases like this remind us that sometimes courtrooms are asked to reconstruct truth from systems designed before the truth ever arrives. I looked at Daniel Carter, then Emily Dawson. And when that happens, justice is not about who won. It is about recognizing how easily reality can be shaped before anyone is given the chance to question it. Silence followed. Not heavy this time, final, and as I closed the file in front of me, I remember thinking one last thing. This case did not just expose individuals, it exposed how fragile perception becomes when narrative is engineered before truth ever enters the room. And even now, years later, we still wonder how many other cases never looked like this one, because they were never allowed to reach the moment where the structure behind them was finally seen. And that is the part of this trial that still stays with me the most.